Hi, I'm Trey, and I chose the Triangle Shirtwaist Fire for my trial. Triangle Shirtwaist Fire occurred on March 25th of 1911 in the Ash Building of downtown New York City. The Triangle Shirtwaist factory occupied a mere few stories of the Ash Building and was owned and operated by Russian immigrants Isaac Harris and Max Planck. The facility was poorly maintained by these two owners and reportedly had scraps of clothing and oil build up around workplaces where smoking was common. On top of that, the Ash Building was not equipped with fire prevention methods like sprinklers, and the 8th floor of the building reportedly had 27 buckets of water only. Because of these factors, a fire broke out on the 8th floor and eventually claimed the lives of 146 workers, many of whom were young women and girls employed by the factory. The defense argued that the building was approved by the New York Department of Buildings, of which it was, but later investigation of the building found it to be neither fireproof nor equipped with adequate fire escapes. The two defendants, Isaac and Max, were both Russian immigrants who came to the U.S. at very young ages. Both of these men also worked in the clothing industry at relatively young ages, with Isaac working in sweatshops and Max eventually becoming a garment contractor. The pair met in the late 1890s and decided that with their combined skills, they should enter a business partnership. This eventually led to the founding of the Triangle Shirtwaist Factory in 1900. The main case of the trial was of Margaret Schwartz, who was one of the 146 workers to die in the trial. She, like many of the other women employed by the Triangle Shirtwaist Factory, was an immigrant from Eastern Europe. She was 24 at the time of her death. The prosecution argued that her death was caused by a locked door. The Ash Building had 3 exits: a Green Street door, a door that led to Washington Place, and a rickety fire escape. At the beginning of the fire, workers fled to the Green Street door, only to find that it was blocked by flames. They then fled to the rickety fire escape that, once overloaded with the crushing weight of other workers, collapsed, killing all those on it. The remaining workers fled to the Washington Place door, which was locked. As the owners held some of the few keys to this building, fingers were initially pointed at them, and they were tried for manslaughter. Some notable characters in this trial would be the defense lawyer, Max Stewart. Max Stewart was a renowned lawyer across New York, and many people recognized him. The lawyer for the prosecution was Charles S. Bostwick, who, at the time, was also New York City's assistant district attorney. For the trial, there were 163 witnesses in total, with around 100 being called by the prosecution. Some of the notable witnesses for the prosecution would include Kate Gartman, Kate Alterman, and May Levantini. For the ultimate verdict of the trial, the jury found the two defendants, Isaac Harris and Max Planck, not guilty. This was because of the defense lawyer, Max Stewart, poking holes in the testimonies of witnesses called on by the defense. He did this by asking Kate Alterman the same question multiple times, to which she replied the same way, with similar keywords. This led to the jury believing that she, and possibly other witnesses, were coached by the defense for a specific response. 3 years after the fire and the end of the first trial, a subsequent civil suit was filed against the defense, ending with Blank and Harris paying $75 per life lost after they lost that subsequent trial. Ultimately, for my opinion on the trial, I think the verdict of not guilty was wrong. I think this because there was outstanding evidence against the defendants. There was over 100 personal testimony of witnesses alongside factual evidence that similarly went against the defense. In conclusion, I think that the final verdict from the jury was incorrect, as there was more than enough that could have been used to convict the defense. Secondly, I think that the American judicial system can be either fair or unfair based on the socioeconomic status of those requiring a service. For example, wealthier clientele will be able to afford higher skilled private attorneys. These attorneys will often be either more recognizable or higher skills in courtrooms. On the other half of the spectrum, lower paid and poorer clientele will not be able to afford these highly skilled attorneys and will have to settle for less experienced, less skilled private attorneys, or in some cases will have to have court-appointed attorneys who are oftentimes less skilled and less experienced than their opponents. Overall, I think the American judicial system's basis for fairness is decided largely in part by the socioeconomic status and wealth of the clientele being represented in court, and their ability to afford decent attorneys.